that you photographed an unsuspecting person, that you possessed a device for wiretap, and you committed unlawful wiretap.
Okay, you're entitled to have a lawyer. We've asked a lawyer to speak with you this morning. Are you going to hire your own private lawyer after today?
Possibly, yes.
Okay. All right. Is this a bail request?
Here is, Your Honor. Thank you.
All right. So, are you ready, counsel?
I am, Your Honor.
All right. So, why don't we hear from the Commonwealth first on the defense?
Thank you, Your Honor. John Herman on behalf of the Commonwealth. Your Honor, the Commonwealth's request for bail is the $20,000 cash bail that was set last evening at the police station. In addition, there are numerous stay-away orders which I'll request at the end of my argument. Sometime last week, Your Honor, town council from Shirley called our office and reported a potential wiretap violation they wanted us to look into. Based on that, state troopers assigned to our office spoke with a town selectman by the name of Kendra Dumont. And Ms. Dumont told the police that she had suspected that the defendant before you had recorded one of her conversations with him. The way she had discovered this was she had asked the defendant's secretary for minutes from a meeting. When she got the minutes, she discovered at the end of the recording of the minutes there was a conversation, a 45-minute conversation between her and this defendant that had been recorded sometime maybe 6 or 8 months ago. And she told the police that that was recorded without her consent. Based on that, state troopers went to the town of Shirley to speak with the defendant, and they had a search warrant for the defendant's computer. When they spoke to the defendant, he admitted to secretly recording, which is a violation of the wiretap statute, the conversation with Ms. Dumont. In addition to that, and through the conversation as it evolved, the defendant had admitted that he'd been recording people for approximately 9 months to 1 year, and that he had recorded dozens of conversations with at least 6 to 8 individuals. During the search of the defendant's office, they found in his briefcase, they found a baby monitor. And they asked him what the baby monitor was for, and he eventually admitted that he had placed the other end of the monitor in the town accountant's office so he could listen to what she was doing inside her office. When asked why he was doing this, he made numerous statements saying he was doing it to, quote, educate himself, that he didn't trust people, and it was a means of learning information, and he wanted to find out who was on his side. During the search of both the defendant, his home, and the office, police found 4 camera pens that are capable of, they're pens with a camera in it, and they're capable of recording audio and video. 2 other recording devices, a few dozen discs and tapes that belong to the recording devices, handwritten logs of dates and times of people he recorded, dozens of flash drives or zip drives, 9 of which were in his pocket, and hundreds, if not thousands, of photos on these drives that had close-ups of female body parts. During the conversation, one of the troopers asked him where else he put the cameras. He eventually admitted that he would on occasion place one of these pen cameras in the woman's bathroom up in a vent over the female stall. And he said that the battery for that pen was about an hour and a half, and he would go in and change the battery or take the pen and put it back in there. And by looking at that camera, we were able to determine that just yesterday he had recorded people with that pen. As the investigation continued last evening, the Commonwealth found out that the defendant put a video recorder, audio recorder, in a plant on his secretary's desk. And he did that because he wanted to see if he could trust her. While looking at the other zip drives from the defendant, we found a drive that was labeled with the secretary's name and the word home on it. While looking at that drive, police found numerous photos of female underwear and bras inside someone's home. The defendant admitted that at least on one occasion he went into this person's home when no one was home. Presumably that's where the photos came from. When we spoke to the female employee this morning, she told police that she did not give the defendant authority to enter his home. He shouldn't have been in there. He shouldn't have taken photos of any of her private belongings. Right now, the defendant is charged with 3 counts: possessing a device used for wiretapping, a wiretap violation, and recording someone in a state of nudity. There is probable cause at this point, based on what we discovered late last night and early today, to charge the defendant with a beanie into a home and numerous other counts of the wiretap statute. In addition, when we looked at the defendant's computer last night, there were numerous pornographic images with this female employee's face photoshopped onto the images. This female employee was again surprised by that and did not give consent for that to happen. So based on the facts and circumstances of the case, Your Honor, and Your Honor knows quite well the factors for bail, the nature and circumstances of this crime, this defendant, at least over a 9-month period and maybe longer, has lived a life of deception and deceit, recording people, taking photos of people without their knowledge, snooping on people, and basically being a voyeur. There are more charges coming down. There's probable cause for B&E and other wiretap violations. The penalty for the wiretap violation is a 5-year state prison sentence. I do intend to review this case for potential indictment. There is a meeting on Thursday in the town of Shirley to discuss the defendant's future employment. Although I don't have firm knowledge of that, I do suspect that his employment will be terminated based on this. So for those facts, Your Honor, for those reasons, the Commonwealth asks for the $20,000 cash bail, a stay-away order from who was the female employee, Kendra Dumont, who was one of the town selectmen, the first person that was recorded, who was the town accountant, and to stay away from Shirley Town Hall and the other 2 town selectmen. I don't have their names right now. I'll provide them to the court. We have information that the defendant recorded at least one of the other town selectmen over this 9-month period. Thank you.
Are you asserting he's a flight risk?
I mean,
$20,000 cash bail.
Certainly, Your Honor.
Because you're asserting he's a flight risk?
Well, I'm asserting that the court can certainly give bail based on the nature and circumstance of the case. The defendant is most likely going to lose his job. He's facing now 5-year state prison felonies, a possible indictment. His whole world has changed from yesterday to today. He's not going to have a job. He's looking at a 5-year state prison sentence. He has lived a life of deceit for over 9 months, recording people without their knowledge, videotaping people without their knowledge. I don't have confidence that the defendant, his word for anything, I don't have any confidence that he's going to, if he tells the court he'll be back, that he will be back after this 9-month episode that we've witnessed.
All right.
Thank you, Your Honor. Your Honor, Mr. Keady is 46 years old. He's lived in Shirley all his life. Graduated from Mayo High School, graduated from the University of Lowell in 1985 with a bachelor's degree. He has had a illustrious career working for the state. He worked for 15 years for the Commonwealth. 8 of those years was as assistant treasurer under treasurers Malone and O'Brien. He also worked in the Budget Bureau and as an assistant controller. He has, following that portion of his career, he worked as a selectman in the town of Shirley. He has worked for 15 years as a selectman and then took over the position of town administrator after the former town administrator passed away. That's a position, Your Honor, he currently holds pending whatever is going to happen with this situation. He is divorced. He is the father of a 13-year-old boy who is extremely dear to him. He has joint custody with his ex-wife. He sees, as part of the custody arrangement, he has his son on the weekend and on one weekday. Currently, in fact, his son is staying with him. His whole family lives in Shirley. As I mentioned, he was born and raised there. His mother lives there. His father has passed away. He has 2 brothers who live there. His son, of course, his ex-wife lives there, and he has nieces and a nephew who live there as well. Suffice to say, Your Honor, that he has extensive ties to that town, not only because of his job, but because of his family. Tells me he does not have a passport. He has every intention of facing these charges and is not a flight risk. As far as his prior record, Your Honor, although I have not reviewed a Corey report, I'm informed that he has 2 prior OUI charges from the 90s. No indication, Your Honor, that he has defaulted or failed to answer for those charges. And again, Your Honor, every indication that he is going to be back here to face these charges. As far as community involvement, he is finishing up the coaching baseball with Shirley, and he has been involved in maintaining and developing the recreational fields in that town as well. Your Honor, notwithstanding the disturbing allegations, my review of the complaint is that Mr. Keady cooperated a great deal with the police, and I don't think that can be denied. He allowed them, he told them, answered all their questions, allowed them into his home, and I think that goes, Your Honor, to his intention to cooperate with this matter, to cooperate with the court, and Your Honor, $20,000 bail, I would submit, is clearly excessive. We're talking about a public servant who simply cannot afford that. He pays child support, pays a mortgage, and has no savings. He is certainly willing to cooperate with probation to do whatever is necessary, Your Honor, to assure the monitoring of his whereabouts, including checking in with them, or whatever else Your Honor thinks is necessary in this situation. Obviously, I have no problem staying away from these people were he to be released. For those reasons, Your Honor, it asks for personal recognizance or that the bail at least be dramatically reduced. Thank you.
Okay, and the only question I have for the Commonwealth is, you anticipate that the town's going to be in contact with them, with some town officials?
Thank you, Your Honor. My understanding from Sergeant Brian Connors of the Mass State Police, who has spoken both yesterday and today with town officials, is that there's a meeting, an emergency meeting Thursday evening to discuss this matter.
So if he's invited to appear at the meeting, you're not suggesting he should have to stay away from the town hall?
I am asking that he stay from town hall. I didn't get the sense that he's going to be invited to that meeting. And again, to be clear, I have not spoken to town officials, but the sense I got from the investigators was that he's not going to be invited to that meeting.
All right, after hearing that, I'm going to set bail him on a $2,500 cash, $25,000 surety, and impose the conditions that he's not to have any indirect or direct contact with Ms. Dumont. He's to stay away from both individuals, and he's to stay away from all members of the Board of Selectmen, and not have any contact with them unless they invite him or request his appearance at some sort of meeting, and he's to stay away from the Shirley Town Hall, the Shirley Public Buildings, again, unless a meeting is scheduled at any one of the facilities to which he's invited. Is that satisfactory to the Commonwealth?
One last name, Your Honor. She was the person who's...
Is she a selectman?
My understanding is she's the town accountant, and she's the person who the baby monitor was put in her office. The selectmen are David Swain, S-W-A-N, and Armand DeVoe, D-E-V-E-A, along with Kendra Dumont.
I meant to say that instead of Dumont. So have no contact and stay away from stay away from the three selectmen and have no contact with them unless they invite his attendance. Does he agree to those conditions?
Yes, Your Honor, he does.
You agree to those, Mr. Keady?
Yes.
You understand if you violate any of the terms and conditions, or if there's any further trouble, you could end up being held in a no bail status. You understand?
Yes.
So you return to court on the day the clerk tells you, with your own private lawyer.
On 1048 CR 811, Attorney Gore was appointed for bail purposes only. The court orders you to recognize the Commonwealth the sum of $2,500 in cash or $25,000 in sureties, which you stand committed at Cambridge Jail. Court has orders that you have no direct or indirect contact, and that you have no contact and you stay away from the three selectmen. That you stay away from Shirley Town Hall and Shirley Public Buildings unless you're invited to do so by the selectmen or for a meeting. If you do not comply with the terms and conditions of this release, sir, you can be held in a no-bail status for a period not to exceed 60 days. This matter stands continued until July 7th or July 24th. This matter stands continued until July 7, 2010 for pre-trial hearings and the appearance of your attorney, sir.
Thank you, Your
All
Honor.
right, I just have one last question. It was mentioned he's coaching baseball. Is that ongoing now, or is it a finish for the year?
It's over, Your Honor.
It's over. Okay.
If you stay committed to the bail money as posted, you do have a right to petition superior court being on bail Saturday today as well.
Okay, thank you.
Thank you, Your Honor.
Okay, and the jury does have a verdict in this.
All right, we'll take a recess and have the jurors sit down.
All rise.
All right, thank you.